Article 16 Form Canon 1491 Form is the shape, appearance and properties of an object or concept attributed through valid action or ritual in accordance with the canons of law that follow this canon. Canon 1492 Form is never the object or concept itself, but the meaning and properties attributed to an object or concept through valid action or ritual. Therefore, all form is fictional. Canon 1493 Only four valid forms exist in law, being person, animal, notion and thing. Canon 1494 An object or concept without valid form has no existence in law. Canon 1495 Any absence, mistake or error of action or ritual associated with form shall render it defective, abrogated, or null to the extent of the severity of deficiency in accordance with these canons. Canon 1496 Such claims as length of existence, custom, consent and first claim have no effect in limiting any defectiveness of form. Canon 1497 Any form derived through action or ritual contrary to the prescript of a valid canon is therefore reprobate, suppressed and not permitted to be revived. Article 17 Person Canon 1498 A person is any valid form attributed to a single member of the Homo sapien species, or equivalent higher order life form, living or deceased, or to the singular identity of a lawful aggregate of the species. A single member form of person is called person, while a valid aggregate of persons is called a juridic person. Canon 1499 A person attributed to less than a Homo sapien or higher order life form is automatically null and void from the beginning. Attributing a person to an animal, notion or thing is an unnatural and unlawful act. Canon 1500 Only four forms of person are valid: divine, true, official and inferior. A divine person is the form attributed to a divine immortal spirit expressed in trust. A true person is the form attributed to a flesh vessel conveyed into a true trust. A superior person is the form attributed to a valid defined office. And an inferior person such as the form of slave identified by Western and inferior Roman law or Talmudic law. Canon 1501 By definition, a divine person possesses higher standing than a true person and a Roman person has the least rights of all persons. Inferior persons such as Roman persons have no jurisdiction beyond the bounds of dictatorships, militia and organized criminal enterprises willing to support such false statutes. Canon 1502 The concept of a natural person is an oxymoron and a deliberate corruption of law. Therefore the term is reprobate, suppressed and not permitted to be revived. Canon 1503 Only seven forms of juridic person are valid: supreme, universal, global, civil, mercantile, union and inferior. Canon 1504 An aggregate of persons as a juridic person without at least two active member of the Homo sapiens species ceases to have form. Canon 1505 No aggregate of persons intending to obtain juridic personality is able to acquire it unless competent authority has approved its statutes. Canon 1506 Excluding divine personality, all persons are temporary. Non-juridic persons are extinguished at the death of the associated flesh vessel. Juridic persons are extinguished in accordance with their own statutes and superior competent authority. No juridic person, excluding society juridic persons formed in accordance with pactum de singularis caelum and associated covenants, may exist for more than 100 years. Canon 1507 Representing a juridic person and acting in its name are those whose competence is acknowledged by these canons or by its own statutes. Canon 1508 Upon the extinction of a juridic person, the allocation of its goods, rights and obligations is governed by law and its statutes. If these give no indication, they go to the juridic person immediately superior, always without prejudice to the intention of the founders and donors and acquired rights. Article 18 Animal Canon 1509 An animal is any valid form attributed to an organic life form that is not a member of the Homo sapiens species or equivalent higher order life form. Canon 1510 A member of the Homo sapiens species can never be depreciated to a separate class attributing they possess the lesser form of an animal. Canon 1511 Any law, precept or decree that separates a class of Homo sapiens into a lesser class as forms of animals is automatically null and void from the beginning. Article 19 Notion Canon 1512 A notion is any valid form attributed to an object or concept that is neither a member of the Homo sapiens species, higher order life form or other hydrocarbon life form. Goods are an example of a notion. Canon 1513 A member of the Homo sapiens species can never be attributed the form of a notion. Any law, precept or decree that attributes the form of a notion to one or more members of the Homo sapiens species is automatically null and void from the beginning. Article 20 Thing Canon 1514 A thing is a temporary form of any non-Homo sapien or equivalent higher order life form object or concept brought before a competent court where the valid form is disputed in accordance with these canons. Canon 1515 A member of the Homo sapiens species can never be attributed the form of a thing. Any law, precept or decree that attributes the form of a thing to one or more members of the Homo sapiens species is automatically null and void from the beginning. Canon 1516 The form of a thing cannot exist outside of a competent court. Therefore, all forms of things resolve themselves to either the form of animal or notion. Article 21 Word Canon 1517 A word is a notional form using symbols and sound to signify meaning, having historic origin normally as part of a language. Canon 1518 All words and their meaning of all languages used to promulgate these canons are subject to the Akkadian lexicons of language. No other meaning or interpretation from any other reference, dictionary and glossary is permitted to be used unless it is sourced from an Akkadian lexicon. Canon 1519 The coupling of words together shows that they are to be understood in the same sense. Therefore, no one is able rightly to interpret one part of a form of words from the whole, unless the grammar used permits it. Canon 1520 Departure from the signification of words is not permitted unless it is evident that they are not conformable to the intent of the whole. Canon 1521 Subsequent words, added for the purpose of certainty, are to make clear the preceding words which require the certainty. Words referred to are to be considered as if incorporated. Canon 1522 Subsequent words, added for the purpose of clarity only, must be isolated by a consistent form of open and closed square brackets. When interpreting the whole, a form of words isolated by open and closed square brackets is to be taken as not existing on the page. Canon 1523 Subsequent words, added for the purpose of list or details of citation, must be isolated by a consistent form of open and closed rounded brackets. When interpreting the whole, a form of words isolated by open and closed rounded brackets is to be taken as secondary form on the page. Canon 1524 Words to which reference is made in an instrument by valid citation have the same effect and operation as if they were inserted in the clauses referring to them. Canon 1525 In non-formal use, general words are to be understood generally. In formal use, general words must be narrowed in meaning either by exposition of the subject or by inclusion in an attached glossary of terms. Canon 1526 Whilst error in form is to be avoided, neither false spelling nor bad grammar vitiates a deed. Canon 1527 The underlining of a word indicates it to be in error or dispute. The striking of a word by a line indicates it is to be removed. Canon 1528 The typography of a word has no material significance to a particular form unless it is clearly states in law and statutes such use for that form is required. Canon 1529 The color color of the typeface used for a word has no material significance to a particular form unless it is clearly states in law and statutes such use for that form is required. Canon 1530 words may not to be taken to import a false demonstration which may have effect by way of true limitation. Canon 1531 No man, woman or person is at liberty to disregard the letter of a canon, in favor of supposed intention. Article 22 Document Canon 1532 A document is a notional form of spiritual or temporal written instrument of one or more pages with each having a front face or obverse and a back face or reverse. There are only five valid forms of documents: supreme, superior, ordinary, general and inferior. Canon 1533 A valid document is any document that conforms in form to the requirements prescribed by the body of canon law known as Astra Maris Divini Canonem in accordance with Pactum de Singularis Caelum. Canon 1534 A supreme document is a valid document issued and sealed by a supreme official person, registered in the Great Register and public record of one heaven and existing. Firstly as a supreme spiritual and ecclesiastical instrument, and secondly as a supreme temporal ecclesiastical instrument possessing full living personality. There is no higher, more powerful nor authoritative document than a supreme document. Canon 1535 A superior document is a valid document issued and sealed by a superior official person, registered in the Great Register and public record of one heaven and existing, firstly as a superior spiritual and ecclesiastical instrument and secondly as a superior temporal ecclesiastical instrument possessing full living personality. It is the second highest and authoritative document of all. Canon 1536 An ordinary document is a valid document issued and sealed by an ordinary official person, registered in the Great Register and public record of one heaven and existing, firstly as an ordinary spiritual and ecclesiastical instrument and secondly as an ordinary temporal ecclesiastical instrument possessing full living personality. It is the third highest and authoritative document of all. Canon 1537 A general document is a valid document issued and registered in a Great Register and public record of a Eucadian society that is not issued by an ordinary, superior or supreme official person. Canon 1538 An inferior document is any document issued by an inferior person such as a Roman person or inferior juridic person. No inferior document may ever be allowed to claim superiority over a general document, ordinary document, superior document or supreme document. Canon 1539 All documents, whether valid or invalid, have at least one obverse and reverse with the primary and most ancient purpose of the front or obverse as the window transmitting the purpose and message of the document, whilst the reverse provides the window transmitting any formal reply, or rebuttal. Canon 1540 The physical alteration of any document, whether it is valid or invalid, without the permission of the original author is an injury that shifts any liability to the party who altered the document without permission. Canon 1541 By definition, an author cannot deny the existence or validity of their own document without causing injury and accepting all liability. Therefore, the return of any document to its author with a perfected reply attached and sealed to the reverse cannot be denied or ignored without the author causing injury and accepting all liability. Canon 1542 When a separate document is attached and sealed to the reverse of the first document, then a reply is perfected in accordance with the most ancient traditions of documents without injury. Article 23 Land Canon 1543 Land is a fictional term used to define the solid terrestrial surface of a planet based rather than any predominantly liquid surface such as a sea or gaseous structure such as an atmosphere or air. Land is also used as a term synonymous with all the solid terrestrial surface of planet Earth. Canon 1544 Land is physical matter within space existing in accordance with natural law as defined by these canons. Therefore as an object, it cannot be owned by a fiction such as an owner, as fictions can only own other fictions. Canon 1545 Except for the divine creator, by divine law and natural law physical matter within space cannot own one another, only themselves. Therefore, the divine creator, also known as unique collective awareness, is the only true owner of all land in the universe, including the planet Earth expressed into divine trust. Canon 1546. In order to enable the lawful ownership of land, a valid fictional form derived from the objective existence of land is required. This is accomplished by undertaking a valid survey of the land and creating a description of its metes and bounds, and then connected in a succession of surveys to the ultimate survey being the rules and mind of the divine creator. When this exists, a valid location may be proven to exist, being a fictional form of land capable of being owned. Canon 1547. When a particular location owing its existence to the first rightful claim of ownership of the divine creator to all land is lawfully conveyed into a true trust, this is called divine right of use, or divinity representing the highest right of use above all other claims of right and title. When some or all of these rights are then conveyed to a superior trust, this is known as realty, or real property, being first right of use of land and immovables by divine right, divinity. Canon 1548. In accordance with the will of the divine creator, the sacred covenant pactum de singularis celum and the seven sacred pronouncements of Eucadia, the divine rights of ownership and all land surveyed as valid locations, has been expressed into true trusts administered by the Society of One Heaven for the benefit of all men, women, higher order beings, animals and life forms living now and forevermore. Canon 1549. In accordance with these canons, the sacred covenant pactum de singularis celum and the seven sacred pronouncements of Eucadia, any and all claims of land ownership, conveyance or trusts that are not in accord with these canons and the will of the divine creator are henceforth null, void from the beginning. Article 24 C. Canon 1550 C, also known as C, is a fictional term used to define a large body of liquid covering the surface of a planet based rather than any exposed solid terrestrial surface such as land or gaseous structure such as an atmosphere or air. The sea is also used as a term synonymous with all the liquid surfaces of planet Earth. Canon 1551 C is physical matter within space existing in accordance with natural law as defined by these canons. Therefore, as an object, it cannot be owned by a fiction such as an owner, as fictions can only own other fictions. Canon 1552 Except for the divine creator, by divine law and natural law physical matter within space cannot own one another, only themselves. Therefore, the divine creator, also known as unique collective awareness, is the only true owner of all seas, also known as seas in the universe, including upon the planet Earth expressed into divine trust. Canon 1553 When sea, also known as sea, owing its existence to the rightful claim of ownership of the divine creator is lawfully conveyed into a true trust, this is called realty, or real property representing the highest right of use above all other claims of right and title. Canon 1554 In order to enable the lawful ownership of the sea, a valid fictional form derived from the objective existence of the sea is required. This is accomplished by undertaking a valid survey of the seas and creating a description of its watermarks, shores, depths and distances, and then connected in a succession of surveys to the ultimate survey being the rules and mind of the divine creator. When this exists, a valid location may be proven to exist, being a fictional form of sea capable of being owned. Canon 1555 When a particular location owing its existence to the rightful claim of ownership of the divine creator to all seas is lawfully conveyed into a true trust, this is called realty, or real property representing the highest right of use above all other claims of right and title. Canon 1556 In accordance with the will of the divine creator, the sacred covenant pactum de singularis celum and the seven sacred pronouncements of Eucadia, the divine rights of ownership and all the seas surveyed as valid locations has been expressed into true trusts administered by the Society of One Heaven for the benefit of all men, women, higher order beings, animals and life forms living now and forevermore. Canon 1557 In accordance with these canons, the sacred covenant pactum de singularis celum and the seven sacred pronouncements of Eucadia, any and all claims of sea ownership, conveyance, trust that are not in accord with these canons and the will of the divine creator are henceforth null, void from the beginning. Canon 1558. When anyone references, writes or speaks of the See, First See, Holy See, or Holy See, it shall mean the seat of power of the Society of One Heaven upon the earth and no other. Canon 1559. Any person, entity, aggregate or group that claims itself to be the See, or Holy See in defiance of these canons is guilty of a solemn offense against all of heaven, all spirits that have ever existed in the divine creator. Such an entity in such serious ecclesiastical dishonor has no spiritual power nor authority whatsoever. Article 25. Building. Canon 1560. A building is a fictional form created through the combined action of a descriptive engineering plan and registration of a structure or edifice upon a valid cadastre location. Canon 1561. A building is always attached to a valid location and not vice versa. Canon 1562. Registration of a valid building is when a valid engineering plan is registered in the Great Register of a Eucadian Society as the one true and accurate current plan of the building. Canon 1563. Any building of a particular cadastre location that is not properly registered into the Great Register of a Eucadian Society is automatically invalid, including any and all associated land title, rights, claims, contracts and agreements. Article 26. Good. Canon 1564. A good is a fictional form of notion determined to be purposeful and useful and therefore possessing a value measurable by some unit of value. Canon 1565. A member of the Homo sapien species can never be attributed the form of a good. Any law, precept or decree that attributes the notion of a good to one or more members of the Homo sapien species is automatically null and void from the beginning. Canon 1566. Unless expressly stated, all goods are held in trust by virtue of the rights of their manufacture, administration, stewardship. Canon 1567. There are only three valid types of goods: supreme, superior and inferior. Canon 1568. A supreme good is any good belonging to a true trust. Canon 1569. A superior good is any good belonging to a superior trust. Canon 1570. An inferior good is any good belonging to an inferior trust such as a Roman trust. All ecclesiastical goods of the Roman cult, also known as the Vatican, are inferior goods. Canon 1571. No good can exist outside of a valid trust. Therefore the highest right of ownership of all possible goods is the Society of One Heaven in accordance with these canons. Canon 1572. Any claim of higher right of ownership of any good than the Society of One Heaven is automatically null and void from the beginning. Canon 1573. When any person subjects goods that otherwise should be supreme or superior goods into being inferior goods, then such a person loses all rights and such rights of goods automatically transfer to the relevant Eucadian society. Article 27. Location. Canon 1574. A location is a fictional form created through the combined action of a valid survey by succession and registration in relation to one unique dimension of temporal space in relation to neighboring space. Canon 1575. Valid survey by succession is the principle that a survey cannot be true to describing a particular dimension of temporal space in relation to neighboring space if it does not belong by succession to a hierarchy of valid survey from the absolute to a particular cadastral survey. Canon 1576. Any survey unable to prove its membership to a hierarchy of succession of detailed survey from a particular cadastre location to the absolute is automatically invalid, including any and all associated land title, rights, claims, contracts and agreements. Canon 1577. Registration of a valid location is when a valid survey is registered in the Great Register of One Heaven as the one true and accurate survey of a cadastre location. Canon 1578. Any valid survey of a particular cadastre location that is not properly registered into the Great Register of One Heaven is automatically invalid, including any and all associated land title, rights, claims, Contracts and agreements. Canon 1579. There are only seven valid forms of location: absolute, universal, galactic, stellar, planetary, terrestrial and cadastre. Canon 1580. An absolute location is a valid survey and registration of the primary location of all locations being the one, the absolute and the unique collective awareness as defined by these canons, and specifically the canons of divine law and natural law. By these canons, there is only one possible absolute location. Canon 1581. A universal location is a valid survey by succession and registration of a sublocation within the surveyed absolute location representing a region of the universe larger than a galaxy as defined by the canons and the Akkadian knowledge indexes. Canon 1582. A galactic location is a valid survey by succession and registration of a galactic location within the surveyed universal location representing a valid galaxy as defined by the canons and the Akkadian knowledge indexes. Canon 1583. A stellar location is a valid survey by succession and registration of a stellar, sun, location within a surveyed galactic location representing a valid star system as defined by the canons and the Akkadian knowledge indexes. Canon 1584. A planetary location is a valid survey by succession and registration of a planetary location within a surveyed stellar, sun, location representing a valid planet as defined by the canons and the Akkadian knowledge indexes. Canon 1585. A terrestrial location is a valid survey by succession and registration of the entire terrestrial land mass of a planet, including its method of survey as defined by the canons and the Akkadian knowledge indexes. Canon 1586. A cadastre location is a valid registration through succession of a surveyed and marked out a tract of land, claim or settlement in relation to other neighboring landmarks and locations within a valid registered terrestrial land survey. Canon 1587. A valid location is not realty, real property, until properly conveyed into a superior trust. Article 28. Divine Person. Canon 1588. A divine person is the highest possible form of person being the form of a living trust corpus, also known as a living body corporate being the divine spirit and energy of a divine trust. A divine person cannot exist without the existence of a divine trust upon the conveyance of divine property and spirit to create it. An aggregate of divine trusts is called a supreme divine trust. Canon 1589. In accordance with the most sacred covenant pactum de singularis caelum, every man, woman and higher order spirit living and deceased is recognized as a full member of one heaven, having a unique membership number issued in accordance with this covenant. This number also represents the existence of an individual divine person and divine trust. Canon 1590. A divine person is owned by the divine trust, administered by the trustees of the treasury of one heaven in accordance with the most sacred covenant pactum de singularis caelum. Therefore, no man, woman, higher order spirit or person may claim higher trust or ownership than the society of one heaven. Canon 1591. The divine person is the first person, the highest person, the primary person from which all other lesser persons derive their consent and authority. Article 29. True person. Canon 1592. A true person is the second highest possible form of person being the form of a living trust corpus, also known as a living body corporate being the divine property of a true trust. Canon 1593. A true person of a true trust formed from when the trustee of the associated divine trust agrees to gift, grant and convey divine rights of use, also known as divinity, into the true trust. A true person can only be formed when an associated divine trust is already in existence. Canon 1594. A true person is owned by the true trust, which in turn is administered by the trustee being the living flesh and brain in accordance with the sacred covenant pactum de singularis caelum. No other lesser trusts, lesser inferior persons can claim ownership, liens, seizures, enforcements or other unlawful acts against a true person. Canon 1595. When a valid registration number from the Great Register is redeemed as the recognition of the existence of a divine person, the associated divine immortal spirit consents and agrees in true trust to ensure the Society of One Heaven administers the rights and obligations of the member as trustees. Canon 1596. Proof of the existence of a true person and true trust is through the issue of a valid live-born record as a divine immortal spiritual being expressed into a flesh vessel. Canon 1597. Any live-birth record within an inferior Roman system which issues a unique number for the flesh of a baby may also be taken as proof of the existence of a true trust, and the inferiority of any inferior Roman person as proof of the existence of the flesh is proof of the existence of the divine immortal spirit. Article 30. Superior person. Canon 1598. A superior person is the third highest possible form of person, being the form of a living trust corpus, also known as a living body corporate, being the real property of a superior trust possessing some kind of office. Canon 1599. An office is the normal term given to a most sacred position of status and title given life and legal personality of its own, to which certain special powers are then bestowed. Canon 1600. Only six forms of official person by status are valid: supreme, superior, ordinary, curator, novice and inferior. Canon 1601. Known only 432, most sacred and ancient official positions are recognized as being permitted to hold any powers and authority by the Society of One Heaven as an office. Canon 1602. A supreme officer, also known as a supreme person and supreme, is any official person defined by unique article within Pactum de Singularis Caelum. A supreme person is the highest form of official person. There is none higher. Canon 1603. If any aggregate, entity, association or other body claiming equal or superior status to a supreme person and is not associated with the sacred covenant Pactum de Singularis Caelum or 7 sacred pronouncements of Euchadia, then such a claim is contrary to the prescripts of divine canon law and is therefore reprobate, suppressed and not permitted to be revived, including any deeds, covenants or other agreements based upon such false claims. Canon 1604. A superior officer, also known as a superior person and superior, is any official person defined by unique article within the three sacred covenants Pactum de Singularis Fide, Pactum de Singularis Islam or Pactum de Singularis Spiritus, or the seven foundation union charters including Carti Sacrarum de Congregatio Globus, Carti Sacrarum de Congregatio Africans, Carti Sacrarum de Congregatio Arabia, Carti Sacrarum de Congregatio Americas, Carti Sacrarum de Congregatio Asia, Carti Sacrarum de Congregatio Europa and Carti Sacrarum de Congregatio Oceania. A superior is the second highest form of official person. Superior officers are the most senior executive administrators of juridic persons, excluding those already identified as supreme officers. Canon 1605. If any aggregate, entity, association or other body claiming equal or superior status to a superior person and is not associated with the sacred covenant Pactum de Singularis Caelum or 7 sacred pronouncements of Euchadia, then such a claim is contrary to the prescripts of divine canon law and is therefore reprobate, suppressed and not permitted to be revived, including any deeds, covenants or other agreements based upon such false claims. Canon 1606. An ordinary officer, also known as an ordinary person and ordinary, is the third highest form of official person. An ordinary is formed by any charter or code of law created in accordance with these sacred canons and not previously named as either a superior or supreme person. Ordinary officers are senior officials of juridic persons. Canon 1607. If any aggregate, entity, association or other body claiming equal or superior status to an ordinary person and is not associated with the sacred covenant Pactum de Singularis Caelum or 7 sacred pronouncements of Euchadia, then such a claim is contrary to the prescripts of divine canon law and is therefore reprobate, suppressed and not permitted to be revived, including any deeds, covenants or other agreements based upon such false claims. Canon 1608. A curator officer, also known as a curator person, and curator is the fourth highest form of official person, and curator is formed by any statute created in accordance with these sacred canons and not previously named as either a superior, supreme or ordinary person. A curator is a manager official within a juridic person. Canon 1609. A novice officer, also known as novice, is the fifth highest form of official person. A novice is formed by any statute or ordinance created in accordance with these sacred canons and not previously named as either a superior, supreme, ordinary or curator person. A novice is a junior or probationary official within a valid juridic person. Canon 1610. An inferior officer is any officer appointed through the statutes of an inferior juridic person under Roman law, Talmudic law or some other inferior form of law. Canon 1611. An inferior officer, by claiming inferior form of law as the basis of their legitimacy, automatically consents to being considered the lowest form of official person. Therefore an inferior officer can never be considered higher than a curator, ordinary, superior or supreme officer. Canon 1612. Any statute that claims an inferior officer of an inferior form of law to be equal or superior to a curator, ordinary, superior or supreme officer is automatically null and void from the beginning, including any and all associated deeds, contracts, agreements. Article 31. Inferior person. Canon 1613. An inferior person is the lowest possible form of person, being the form of a trust corpus, also known as a body corporate, being the inferior property of an inferior trust by Western and inferior Roman law, Sharia law or Talmudic law. Canon 1614. An inferior person, such as a Roman person, is a person created by the legal spell curse system of the Roman cult, also known as the Vatican, also known as the Roman Catholic Church, for which they falsely claim ultimate ownership not only of the person, but associated flesh, mind and soul. Canon 1615. An inferior person is by its very definition inferior to an official person, which is lesser in standing than a true person, which is lesser in standing than a divine person. An inferior person can never be considered superior to a divine person. Therefore, no law based in inferior persons can ever be lawfully considered equal or higher than these canons. Canon 1616. As every man, woman and higher order spirit is granted a divine person in accordance with the sacred covenant pactum de singularis caelum, excluding the conditions of necessity. When a man or woman willingly chooses to be associated with an inferior person, such as an inferior Roman person or Roman slave, such demonstration of distortion of reality, lack of ability of reasoning and logic is grounds to declare such a man or woman through their inferior person as incompetent. Canon 1617. Where a man or woman through their inferior person is lawfully declared incompetent, the Society of One Heaven or the nominated Eucadian Society shall lawfully assume full power as guardian and trustee for the inferior person. Article 32. Supreme juridic person. Canon 1618. A supreme juridic person is an aggregate of 100 divine persons formed as the body of a supreme trust, when such divine persons share similar characteristics and no longer own a living flesh vessel. Canon 1619. There is no higher form of juridic person than a supreme juridic person. The highest supreme juridic person is the aggregate of all supreme juridic persons represented by the Society of One Heaven. Canon 1620. As all divine persons are formed from divine immortal spirits, supreme juridic persons possess conscience and legal personality as a living spirit. It is both illogical and fraudulent to compare a supreme juridic person with a corporate person, being a mortmanis person, also known as a dead ghost devoid of conscience. Canon 1621. No inferior juridic person, also being corporate person, also known as a mortmanis or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a supreme juridic person. Article 33 Universal juridic person Canon 1622. A universal juridic person is an aggregate formed as the body of a universal trust. Canon 1623. A universal juridic person is the highest possible form of juridic society of any and all types of society within the universe. There are only two types universal juridic persons, namely Eucadia and universal, gold, credits. Canon 1624. As all true persons are formed from divine persons themselves, formed from divine immortal spirits, universal juridic persons possess conscience and legal personality as a living spirit. It is both illogical and fraudulent to compare a universal juridic person with a corporate person, being a mortmanis person, also known as a dead ghost devoid of conscience. Canon 1625. No inferior juridic person, also being corporate person, also known as a mortmanis or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a universal juridic person. Canon 1626. Eucadia has dominion over all existence and all therein. Article 34 Global juridic person Canon 1627. A global juridic person is an aggregate formed as the body of a global trust. Canon 1628. As global juridic persons are formed from divine persons holding conscience and life, all global juridic persons possess legal personality as living beings with a spirit. Canon 1629. No inferior juridic person, also being corporate person, also known as a mortmanis or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a global juridic person. Article 35 Civil juridic person Canon 1630. A civil juridic person is an aggregate formed as the body of a civil trust. Canon 1631. As civil juridic persons are formed from divine persons holding conscience and life, all civil juridic persons possess legal personality as living beings with a spirit. Canon 1632. No inferior juridic person, also being corporate person, also known as a mortmanis or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a civil juridic person. Canon 1633. If two civil juridic persons are so joined that from them one is constituted which also possesses juridic personality, this new juridic person obtains the goods and rights proper to the prior ones and assumes the obligations with which they were burdened. With regard to the allocation of goods in particular and to the fulfillment of obligations, however, the intention of the founders and donors as well as acquired rights must be respected. Canon 1634. If a civil juridic person is so divided either that a part of it is united with another civil juridic person or that a distinct civil juridic person is erected from the separated part, the authority competent to make the division, having observed before all else the intention of the founders and donors, the acquired rights, and the approved statutes, must take care personally or through an executor to the financial obligations and disbursement of remaining assets in accordance with the original intentions of the members. Article 36 Mercantile juridic person Canon 1635. A mercantile juridic person is an aggregate formed as the body of a mercantile trust. Canon 1636. As mercantile juridic persons are formed from true persons themselves, formed from divine persons holding conscience and life, all mercantile juridic persons possess legal personality as living beings with a spirit. Canon 1637. No inferior juridic person, also being corporate person, also known as a mortmanis or dead ghost, can have superior jurisdiction over a living spirit. Therefore no inferior Roman juridic person may ever have superior jurisdiction over a mercantile juridic person. Canon 1638. If two mercantile juridic persons are so joined that from them one is constituted which also possesses juridic personality, This new juridic person obtains the goods and rights proper to the prior ones and assumes the obligations with which they were burdened. With regard to the allocation of goods in particular and to the fulfillment of obligations, however, the intention of the founders and donors as well as acquired rights must be respected. Canon 1639. If a mercantile juridic person is so divided either that a part of it is united with another mercantile juridic person or that a distinct mercantile juridic person is erected from the separated part, the authority competent to make the division, having observed before all else the intention of the founders and donors, the acquired rights, and the approved statutes, must take care personally or through an executor to the financial obligations and disbursement of remaining assets in accordance with the original intentions of the members. Article 37. Union juridic person. Canon 1640. A union juridic person is an aggregate formed as the body of a union trust. Canon 1641. As union juridic persons are formed from true persons themselves formed from divine persons holding conscience and life, all union juridic persons possess legal personality as living beings with a spirit. Article 38. Inferior juridic person. Canon 1642. An inferior juridic person is an inferior aggregate person in accordance with inferior custom or claimed laws such as Roman law or Talmudic law. Inferior juridic persons have no authority, nor jurisdiction by law, except through force and corruption. Canon 1643. An inferior juridic person is by definition a corporation under Roman law, representing the body corporate or the corpus of an estate. Therefore inferior juridic persons are mortmanes, or dead ghosts in contravention of ancient principles of law preventing such abominations, and ever permitting them to have legal personality nor hold property. Canon 1644. By definition, an inferior juridic person is a dead ghost, devoid of life and spirit. Therefore an inferior juridic person can never have higher standing than a juridic person or persons that possess life and spirit. Canon 1645. Under inferior Roman law, an inferior juridic person may lawfully obtain and hold limited property rights only. An inferior juridic person can never lawfully obtain nor hold real property. Canon 1646. An inferior juridic person cannot have nor claim the character of a moral person. Therefore an inferior juridic person cannot confer juridic personality. Canon 1647. In accordance with divine will, divine law, natural law and these canons, the Roman cult also known as the Vatican, also known as the Roman Catholic Church, is an inferior juridic person. Canon 1648. In accordance with divine will, divine law, natural law and these canons, any person formed directly using Talmudic law is automatically an inferior juridic person. Article 39. Time. Canon 1649. Time is a fictional form of measurement belonging to an accepted form of reality defining a limited quantity of space and or continued existence between two successive events or actions or the period through which an action, condition or state continues. Canon 1650. The laws of time by natural law are not the same as the principles of time according to positive law, as time as a fictional form within a system of reality be suspended, elongated or reduced. Canon 1651. The most superior form of time is the Akkadian time system as defined by the most sacred covenant Pactum de Singularis Caelum. All other forms of time are inferior. Canon 1652. As the Akkadia time system is in harmony with the true cycles of the earth and the most ancient time-keeping systems of the oldest priest-king bloodlines, the Akkadia time system also represents the one true and only valid time system. Canon 1653. Consistent with the acceptance by Roman law, Talmudic law and Sharia law that such inferior time systems will be lawfully abrogated at the end of days, all three time systems are hereby rendered null and void. Therefore, the use of Roman time, Talmudic time, Islamic time or another time system on an official form has no effect. Canon 1654. As Roman time is hereby rendered null and void, all claimed authority, power, right and influence derived from this system is also hereby rendered null and void. Canon 1655. The use of any other time system other than the Acadia time system for official and valid form is forbidden, except when documents are produced specifically for use in inferior jurisdictions. Article 40. Machine. Canon 1656. A machine is a device containing one or more inorganic moving parts capable of harnessing, transmitting or modifying energy. A machine may also be correctly defined as a good. Canon 1657. A valid machine is any machine whereby its make and model, including blueprints, are properly registered. It possesses a nameplate and has been tested and certified to be mechanically sound to its registered specifications. Canon 1658. As all machines are built from objects and concepts, all machines by default are held in trust in accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, consistent with all objects and concepts. Canon 1659. A machine that is not properly registered with the Akkadian Society in accordance with these canons is an unregistered machine. Canon 1660. An unregistered machine has no rights to use or be used on or with the property of a Akkadian Society. Article 41. Register. Canon 1661. A register is a ledger of records into which regular entries are made of details of form regarded as sufficiently important to be exactly recorded. Hence, for anything to regarded to be on the record is literally to be recorded into a register. Canon 1662. A valid register has a specific purpose, level of importance relative to other registers, condition of entry and conditions of transfer of certain rights in accordance to valid law or statute. When two registers are compared, the one having superior standing in the law has rights over the other register. Canon 1663. The highest and supreme register of all possible registers is the Great Register of One Heaven in accordance with Pactum de Singularis Caelum. Any law claiming equal or higher standing to the Great Register of One Heaven is automatically null and void from the beginning. Article 42. Record. Canon 1664. A record is an account of some fact, event or form preserved as knowledge, particularly in writing, knowledge, evidence or information particularly within a register. Record also refers to reference to the material itself. Canon 1665. When a record is entered into the Great Register and Public Record of One Heaven, the record and form itself is considered to possess spiritual life. Canon 1666. No inferior person or inferior juridic person is permitted to be ever entered as a record in the Great Register and Public Record of One Heaven. Canon 1667. In accordance with these canons, any entry of an inferior person or inferior juridic person into the Great Register and Public Record of One Heaven is automatically null and void from the beginning. Article 43. Value. Canon 1668. Value is a fictional form being the assignment of a degree of importance, desire and numerical value in currency to a particular form. Hence, value is a subjective ranking of a form relative to other forms, often on simple monetary value. Canon 1669. A good is worth as much as the value at which it can reasonably be sold. Canon 1670. The most important, the rarest and therefore the most valuable form in history is objects believed to be divinely inspired and sacred. Canon 1671. The least important, the commonest and therefore the least valuable form is objects and matter considered to be abundant and easily available. Canon 1672. By definition, the most valuable form of all possible forms is these canons and the Sacred Covenant Pactum de Singularis Caelum. No object, nor form may be considered more valuable. Canon 1673. No man, woman, person, aggregate, entity or spirit may claim ownership of the Sacred Covenant Pactum de Singularis Caelum other than the Divine Creator. All copies, reproductions, abstracts and extracts of the Sacred Covenant remain at all times the sole property of the Divine Creator. Article 44. Asset. Canon 1674. In a general sense, an asset is a fictional form representing other forms regarded to possess a formal unique identity and value. As such, An asset is a net store of real value. Canon 1675. In a formal sense, an asset is any sufficient effects, property or goods of sufficient value enough to discharge any burden cast upon a trust or estate in satisfying its debts. Therefore assets do not exist without some relationship to a trust or estate. Canon 1676. Assets may be defined as either tangible or intangible. Canon 1677. A tangible asset is any asset, such as buildings, land, equipment etc. that has physical form. Canon 1678. An intangible asset is intangible personal property, acquired for money, that does not have a face value or a ready market. An intangible asset is also defined as any valuable property of a business that does not appear on the balance sheet, including intellectual property, customer lists, and goodwill. Article 45. Debt. Canon 1679. In a general sense, a debt is a fictional form representing an obligation by one or more persons due to another one or more persons is whether it be to perform an act, or make payment of certain currency, goods or effects. Canon 1680. In a form sense, a debt is a form possessing negative value that may only be effectively discharged providing assets of sufficient value exist within the trust or estate to render a zero balance or remainder in the accounts. Article 46. Account. Canon 1681. An account is a fictional form for the administration of currency transactions in trust or estate. Account can also refer to the actual statements produced summarizing monies received and paid with calculation of the balance. Canon 1682. Neither an asset nor liability is held validly unless it is recorded into the proper account of the trust or estate in accordance with these canons. Article 47. Income. Canon 1683. Income is the sum of all earnings received from ownership, lease and use property including business, land, investments and one's own work. Canon 1684. Under inferior Roman law, a tenant of a possessory estate has the right to gain a fair income from the land and its immovables from any leaseholders. This is called tax. Canon 1685. Income gained from possession of property to which the person is not entitled is fraud and unlawful. Canon 1686. Unless a person holds valid title to property issued by a valid Eucadian society, then any income received from use of property is unlawful. Article 48. Liability. Canon 1687. A liability is an obligation, debt or responsibility owed by a person to another within the context of trust and estate law. Canon 1688. A liability does not exist if no trust or estate exists. Canon 1689. The obligation to a liability is defined by the relationship of the person to the trust or estate and the rules of agreement. A person cannot assume the liabilities of another without having a relationship to the trust or estate that holds the liability. Canon 1690. The holder of an original agreement generally accepts all liabilities of the trust or estate administered by that instrument, unless another related to the trust or estate consents to act as surety to the liability. Canon 1691. As it is the obligation of the trustee, or executor or administrator to administer all assets and liabilities, any acceptance of liability on the part of a beneficiary may only be temporary, according to some fixed term or conditions. Canon 1692. Once a beneficiary completes any obligations or agreement associated with acceptance of surety for a liability, the obligation for any continuing liability must automatically return to the trustee, or executor or administrator of the trust or estate. Canon 1693. When a person dishonors an instrument, properly formed and registered, then a deed of dishonor may be issued. When a deed of dishonor properly formed is dishonored, a deed of protest may be issued. When a person has dishonored three perfected instruments, they have then fully consented and accept any attached liability even if such consent and acceptance has not been made orally or in writing. Canon 1694. When a person uses any property of a trust or estate without permission, they automatically assume relationship with that trust or estate as a beneficiary and accept full liability attached to the use of that property. Canon 1695. A person who admits mistake and error in trespass on the use of property of an estate or trust without express permission is automatically freed of any liability obligations, and full liability returns to the trustee, or executor or administrator. Canon 1696. Any trustee, executor or administrator that refuses to act within their obligations and except when an obligation is returned upon admission of a mistake or non-consent as surety is guilty of a gross breach of duties and automatically becomes personally liable for any and all associated liabilities. Canon 1697. Any liability created in fraud automatically becomes the personal obligation of the person who committed the fraud. Article 49. Currency. Canon 1698. Currency is a formal system of money based on some standard unit of measurement, a store of value and a medium of payment and exchange. Money is anything that is generally accepted in exchange as payment for goods according to some estimated value. Canon 1699. While the key function of money is to act as a medium of exchange, when money is formalized to be recognized as a store of value, a unit of account and method of payment according to certain rules, then it may be regarded as currency. Canon 1700. All currencies and therefore money may be defined into two types according to the method of underwriting the value of the money, commodity and property. Canon 1701. Commodity currency is the simplest form of currency whereby the money itself is the underwriting and carrier of value. The most common examples of commodity currency are gold and silver coins, now rarely minted in favor of debased metal coins of less intrinsic value. Canon 1702. Property currency is any currency that uses rights of property by claim, lien and other mechanisms as the method of underwriting. All property currency is based upon the rules of negotiable instruments and the associated concept of temporary trusts in which to convey the property. Canon 1703. All notes, also known as bank notes and bills, are by definition fungible negotiable instruments. Therefore property currency based upon one or more classes of property conveyed into temporary trusts as its store of value. A bank may choose to issue one bank note against one temporary trust for one trust corpus of property, or may choose to issue multiple banknotes against a temporary trust to the total value of the trust corpus. Canon 1704. The two most common forms of property used to underwrite currency as negotiable instruments are rights of claim, also known as rights of redemption, and liens, most notably maritime liens. Currency based upon redeemable value was most common in permitting the property of the instrument to be converted into a good of equivalent value, in particular gold or silver. However, most currency based on redeemable property has been withdrawn in favor of currency based on liens. Canon 1705. The principle of property currency based on liens is the acceptance by an estate that because the property under lien cannot be effectively seized, the lien holder is granted permission to monetize their right and then sell the debt to recoup their loss. Canon 1706. The significant difference between monetized maritime liens conveyed into trust and issued through the structure of property currency and negotiable instruments is that a monetized bill of exchange is not permitted to be dishonored by any merchant within the Roman system, without severe penalties. This is because maritime liens represent the highest lien coming from the authority of the highest estates, and to dishonor this authority is to dishonor the entire global Roman land, property and finance system of the world. Canon 1707. In each estate deliberately bankrupted and forced to issue equitable title property currency through a private reserve bank, the live birth record of each newborn child is monetized as a bonded promissory notes and then sold and conveyed into a separate sestuek, vi, trust per child owned by the private reserve bank. Upon the promissory note reaching maturity and the bank being unable to seize the slave child, a maritime lien is lawfully issued to salvage the lost property and itself monetized as currency issued in series against the sestuek, vi, trust. Thus the currency of private reserve banks is only leased by the population, who then pay rent in the form of interest for currency they underwrite because of the monetized maritime liens issued against them as Roman slaves. Canon 1708. As the society of one heaven is the first sea and the one True and only Holy See, all currency issued under maritime liens is now the property and subject to the true see in accordance with these canons in the Sacred Covenant Pactum de Singularis Caelum, Canon 1709. Any treasury, or reserve bank that refuses to acknowledge that any currency issued under maritime liens is ultimately the property of the First See and the one, true and only Holy See being the Society of One Heaven is open consent and agreement that the rules guiding the global Roman financial system of currency no longer apply and are null and void. Canon 1710. Any treasury, bank or financial institution that dishonors currency issued by a valid Eucadian society commits an act of extreme dishonor and by such action openly accepts full liability and underwriting of such an instrument. Failure to further honor such a valid instrument is open consent by the particular Roman institution that the rules guiding the global Roman financial system of currency no longer apply and are null and void.